unable to answer.
Correct, Commissioners.
Which part of the question is creating difficulty?
The one you asked me, Commissioner.
I think, Mr. Law, it is, I think, properly construed. He refuses to answer the question. Can we proceed on that basis?
Do we accept Commissioner Baloyi's suggestion that you refuse to answer the question?
Chair.
Yes, Mr. Mpofu.
Yeah, Chair, maybe to save the time of the Commission so that we don't go through this painfully again. This witness, if he feels that there is a question put to him whose only value is to expose him to disciplinary action but has nothing to do with the mandate of the Commission in his view, then he will be uncomfortable to answer that. So that he doesn't have to do it again and again and annoy Commissioner Khumalo by referring so much to the HR threats. I think this point has been made, I don't know how many times now.
No, Chair. It has not been made.
Can I just finish, please? Yeah. So, and the point which, at least, let me not speak for the witness, let me speak for myself. The point that I made in the morning was that, and I gave examples, and that's what we were talking about, that unit. Our view is that there are two units. There's one sitting somewhere at HR, one sitting at the police that is watching these proceedings, ready to pounce as they did in January, with all sorts of trumped up and spurious charges. So if this exercise is to show that General Senona is a bad manager or whatever, then we accept that criticism. But we're not going to go into specifics about, as I said in the morning, minutiae. If I may take advantage of this chair, just to make a wild example. At some stage in my life, I was the CEO of the SABC. But if you ask me what happened in the Northwest office or whatever, I've never even been there. Or how to hold a camera and somebody held it upside down, you know. So, but I don't want to go to issues of management and organizational design. The issue is that the general is saying that he takes responsibility as the head, but he can't be asked about, did this one open this key or whatever, and at that level. If you are a manager, you rely on people. You can't, it doesn't mean if you're a CEO, you must know what's happening in the technology department, in the accounting department, in this and this, at the level of that detail. But as I say, I don't want to maybe stifle the questioning, but with the greatest respect, it's not clear what needs to be achieved in relation to the terms of reference.
May I clarify with your leave, Chair?
May I just ask a question? Does the fact that with regard to this, and in particular the storage, does the fact that the General had taken a particular interest in this and even went to Port Shepstone himself, even took over the keys, does that not distinguish it, for example, from your situation?
Yes.
At the SABC of not necessarily knowing what is happening at the Northwest office of the SABC?
Yes, thank you, Chair. It may or may not, but I'm making a different point. The point is that to what end, in relation to the terms of reference? The General says he was there. Commissioner Baloyi explains, well, I think it was Commissioner Baloyi or Commissioner Khumalo. All right, you might not know everything, but on this occasion you were there, you actually saw it happening. And he says, yes, I did. Maybe I made a mistake. What more must he say? Now in hindsight, he knows he probably should have said, why are these things not being begged? But he did not do it. So how does that assist us to say, okay, you should have done it. Then we can be here all day saying, yeah, you should have begged them. No, I didn't beg them. No. So for what particular purpose?
Commissioner.
Apart from exposing him to somebody who's going to say, you were there, you actually saw all these transgressions, now we're going to pounce on you. What other purpose can it possibly serve?
Commissioner Baloyi, of course I'm paraphrasing, also made the point that here we have what I would refer to as a comedy of errors / inadvertence or whatever one may call it, from the beginning all the way to the end. And that one wants to inquire into whether these were not already setting up a scene for the theft.
Agreed.
Which is why, as Commissioner Baloyi, I think, then asked, or rather said, we should therefore inquire into all these errors, it may be errors or errors in quotation marks, so as to have a full picture as to what exactly happened and why.
Yes.
That will help either exclude any wrongdoing on the part of whoever the role players were, or not exclude wrongdoing. So, in fact, it calls to mind a judgment by Justice Froneman, which I'm sure you are well aware of, the judgment of all pay in the context of procurement. Justice Froneman said, there may be something that looks like mere inadvertence in terms of taking the required steps. You have to inquire into that because it may look like inadvertence when in fact it was an inadvertent step taken deliberately in order to cover, for example, fraud in the procurement process. So sometimes these inquiries, may be necessary in that context. And you yourself, in the morning when you addressed, you said that, yes, there may be HR issues and there may be issues that fall under the Commission's terms of reference, but, and this is what is important in what you said, but there are no bright lines.
Of course.
Yes.
Thank you, Chair. There's nothing more to say. That's exactly why Commissioner Baloyi quoted me. What you've just told me is what I said to this commission in the morning. We're not saying don't ask about incompetence, because who knows, maybe the incompetence was deliberate. But really to go on for the whole day about whether this thing was put in a bag or not, it was not put in the bag. It was wrong. It should have been put in the bag. Can we move on then?
Well, the answer of the witness, Mr. Mpofu, is he refuses to answer. The question had to be put to him, whether he saw that these things were not in the bag. The question, and I must say, it's a fair question to ask in the circumstances. I've respected, for present purposes, the way he's chosen to respond, but I think for me the more important point that I wanted to make was, and it's a pity it comes late in the day because of how he's responded now, it's for the Commission ultimately to determine whether the evidence that we have gathered, does it fall within the terms of reference or not. So I think it's an artificial way to try to, even for the witness himself to say, well, that has nothing to do with your terms of reference. I expect you will agree, Mr. Mpofu, that ultimately the Commission is going to have to look at the entire record.
Yes.
Some questions we will find, or some answers in some conversations, we are for sure going to find. Doesn't deal with our terms of reference, but it had to be canvassed because we were looking at trying to see what does it tell us.
Yes. May I respond, Chair? Thank you, Chair. No, I think we're on the same page as far as that's concerned. All I'm doing really, I'm here to protect the interests of this client. I'm simply saying, if and when he says to Ms. Zello, I'm uncomfortable answering that question about the bags or whatever, because it might expose me to something else. All I'm saying is to put that into context so that the commission doesn't read something else into that, to think maybe that's because he stole the drugs or whatever. All he is explaining the reason why he's doing this. In America, it's called taking the Fifth Amendment, right? He is saying, I'm uncomfortable in answering that question because it's going to expose me to something else. Honestly, that's all that's all I'm saying. You can say from someone taking the Fifth, oh, that means he's guilty, that's fine. Someone can say that. Or you can say he's protecting himself from further jeopardy. That's up to the commission, but I'm just putting that into perspective.
Just to conclude this, Mr. Mpofu, it's actually something I thought of as the general was responding quite early on. I forgot to raise it when I was engaging you. In the context, for example, of there being criminal proceedings in the background, a witness may say, I will not answer for fear of self-incrimination, which is understandable under Section 35 of the Constitution. In this context, what would, assuming that the question is relevant to the terms of reference, I want us to avoid the question, but this one is not. I just, as a matter of principle, want to understand the legal basis for a witness where there are pending disciplinary process, what the basis for remaining silent would be.
Yes. Thank you, Chairperson. That's a valid.
I'm not saying there isn't.
No. I'm not taking it that way either. I think we're all trying to explore the same thing. Chairperson, as you know, I'm the first one to say, that's why I said in the morning, I'm not raising this at a technical level. It's true that Section 35 doesn't apply to this situation. To you and me, that might make a difference. But we must put ourselves in the shoes of people. Whether I'm exposed to criminal prosecution or I'm exposed to being fired at work, it might make zero difference to me. I'll just leave it at that. So, it's nice, the lawyering about, okay, does this now mean self-incrimination for the purposes of prosecution? It's all very nice academic debate. But if you think that when I leave here on Monday, I might be faced with something that's going to take food from my children, then quite frankly, it's the same effect as to whether or not you should expose yourself to this danger or that one.
I get the effect, and my reference to Section 35 of the Constitution sought merely to emphasize the difference or the distinction. Yes, that was merely, so the point of substance was more, in this context, what is the legal basis for saying, I choose not to respond to this question? Yes. And I have not heard a direct answer from you. Well, I get and I accept your point about the effect may actually be the same. Sometimes it may actually even be worse to lose your employment. I get that. So just as a matter of law, then what would the basis be?
Well, as a matter of law, there might be zero basis, Chair. But as a matter of real life, whether you expose yourself to in other words, Chair, all I'm saying to you, Chair, is in real life, whether I'm exposing myself to some policeman coming into my house on Monday, or some supervisor at work coming to my office on Monday, in real life, that's the same thing. In law and in the philosophies of criminal law and criminal procedure, there's a big difference. That's why there's a difference between Section 35 and Section 34 of the Constitution, because they address different situations. But those are niceties of professorial rectitude.
Chair,
Perhaps something that we must place on record so that I'm sure you are aware of it, Mr. Mpofu, but the General should also be aware of it. General, there's also, I think it's Section 6 of the Commissions Act. It's Section 6 of the Commissions Act. The Act itself, yes, which requires of witnesses to answer questions satisfactorily, fully and satisfactorily. If there is no legal basis, and in this instance I'm not aware of any, I'm not saying there's none, but as presently advised, I'm not aware of any. So I thought, in fairness to you, I should bring the provisions of Section 6 to your attention. And they go so far, it's not just requiring answering fully and satisfactorily. It's this failure to do so is on pain of facing criminal proceedings. So I thought I should just bring that to your attention. Not only you, but in case others who are listening and who may come to testify before the Commission, and who also happen to have disciplinary proceedings pending, may think if we do not raise this, then it's the way out for everyone. I have disciplinary proceedings pending, and therefore I am not going to respond to this question. I do take Mr. Mpofu's point about issues that are or are not within or the terms of reference of the Commission. Where an issue is raised around that, we can engage before, of course, as Commissioner Baloyi said, we as the commissioners take a decision because it falls upon us to do so. We can, of course, engage counsel where there is counsel, or the witness themselves where the witness is not represented. We can engage on that. Does this fall within the terms of reference or does it not? And therefore, on that basis, if we agree, once the witness or counsel has raised the point and we agree upon engagement that indeed it doesn't, we may not force or push the witness to respond to that kind of question. But it can never be on the basis that there are pending disciplinary proceedings and therefore I am, quote unquote, uncomfortable to respond to that question. It can never be on that basis. I've not given Ms. Silo an opportunity to respond. Or perhaps before she responds, do you want to respond to the observations I've just made, Mr. Mpofu?
So that she can respond to
so
everything.
yes.
Chair, well, this thing is growing to be even worse than I suspected. I thought, and which I was trying to prevent, Commissioner Baloyi was rightfully saying to the witness, you then have to understand if you are uncomfortable, you are uncomfortable, but the Commission will take that into account. And that's, I can't quibble with that. He has to weigh which risks to do, whether to offend, whether to annoy the advocate still or to lose his job. That's his uncomfortable choices. I accept that. But now from what the chair is saying now, with the reference to Section 6 of the Act, that's a completely different kettle of fish, because that means now he's exposing himself to criminal prosecution. Well, that if that is the attitude or the jeopardy.
No, may I come in?
Yes.
May I come in, Mr. Mpofu?
Please.
All I'm saying is, in fact, I accepted a point that you made, which is that if the question raises issues that have nothing to do with the terms of reference of the Commission, then what I'm saying will never arise. There can never be a question of the application or applicability of Section 6. Did you get me?
I understand, and I agree. You know.
And I'm not being question specific on this.
Yes,
I'm stating it generally, and I just want the general to be aware that there is such a provision.
Yeah.
Then the question of how to respond to a particular question in the context of what falls within and what does not fall within the terms of reference is an issue that there may then be an engagement.
Some legal debate. No, Chair, I accept that holistically. And I do sympathize with the remarks you made, Chair, that you don't want to open the floodgates for rogue people to come here. Every time you ask a question, they say, well, I've got some disciplinary thing. That I accept. I was just putting it in the context of this specific witness and what he said in the morning. But I accept.
Yes. No, thank you. Thank you, Mr. Mpofu. Yes, Ms.
Thank you, Chair. A number of issues have been raised. I'll start with the simplest. When we started, we dealt with the seizure of the drugs at the harbour. And we were to go to their entry into the SAP 13 register at Isipingo. A suggestion was made that the General accepts every concession made by those who were responsible for that seizure. And I needed to clarify that with the General, and he so confirmed. I accepted that on the basis that he was not present. He cannot comment on what went down. He will live with the concessions made. I then shifted to Port Shepstone, where he was present now. These are two different scenarios. And